Hello all. Today I am here to talk to you about the number one mistake that people make when they are putting together their trust-based estate plan. So you've heard me talk in the past about the fact that there are will-based estate plans and trust-based estate plans. On another video I'm going to talk about the biggest mistake with will-based estate plans or estate plans in general, but today we're talking about trusts. I am Don Rolfe, the owner and founder of Northwest Legal Planning, an estate planning and probate law firm located in West Linn, Oregon. And the number one mistake that people make with their trust-based estate plans, and what can happen if this mistake is made, is that they fail to fund their trust. And you've heard me talk about trust funding before. And basically what that means is you set up a trust, which is sort of, it's just you, but it's kind of a different entity of you. And it's like a bucket. And in order for the trust to work, you need to put your assets, your things into that bucket. So generally when you set up your estate plan with a trust, you're going to do some initial funding with the attorney that you work with. But then there's other things that are on you to make sure that they get funded into your trust. So the things that I work with my clients on is we look at real estate and we do deeds to transfer their homes and other real estate that they have into their trust. We do an assignment of all of their personal property into their trust. And then we talk about and give explanations on how to transfer all of your other assets. So for cash accounts and investment accounts and checking, savings, those sorts of things, what we generally do is we retitle those accounts into the name of the trust with you as the trustee or the signer. And for other accounts like retirement accounts, perhaps life insurance, we take a look at the beneficiary designations and make sure that we're either naming the right individuals or the right sub-trusts that we're creating inside of your revocable living trust, just to make sure that all of your bases are covered, all of your assets are getting inside of the trust where your trust can actually work on them during the times that you are incapacitated and then after you pass away. Now, if you have questions about this, go to myestateplanmeeting.com and set up a complimentary half-hour consultation with me, and I can answer those questions and explain to you your estate planning options. Now, what happens if you fail to fund your trust? Well, essentially, if you become incapacitated and your assets haven't been moved into the trust, your successor trustee steps in and will have no power over your assets because as a successor trustee, they don't have power over assets that are outside of your trust. So they wouldn't be able to write checks to pay your bills. They wouldn't be able to withdraw funds from investment accounts if it was necessary to pay your medical bills, all of those sorts of things. As the trustee, they wouldn't be able to do that. They would have to try to rely upon a power of attorney that you may have entered into, a durable power of attorney, hopefully, and that can be hit or miss. Because the institutions, whether they're investment houses or banks or anywhere else, they can reject a power of attorney even though it's been lawfully signed, it's still valid, and all of those sorts of things. There is absolutely nothing in the law that says they have to accept that power of attorney and allow your agent to operate under it. So that's during your incapacity. That can cause a lot of problems where your successor trustee is not able to actually manage your day-to-day accounts and activities and make sure bills are paid and all of those sorts of things because your assets haven't been funded into trust and they will not have power over them as the successor trustee. And then the next is after you pass away, one of the big reasons that we put together to trust-based estate plans is we want to avoid probate, which can be a costly and prolonged endeavor. That's basically a lawsuit against yourself after you've passed away so that you can give the things that you have to the people that you want. So if you have not funded your trust, if you have not transferred your assets into your trust at the time that you pass away, then essentially what's going to happen is a probate will be necessary. Because that's the only way to move those assets that are in your own personal name and not titled into the trust. So a probate will have to be opened. Your personal representative in the probate will have to, your estate will have to pay the court costs and probably some attorney's fees for getting the probate completed. And then from the probate, all of those assets then get transferred into the trust, and then the trust has to be administered after that. So it can really drag out the process if we don't have your trust funded properly. So that, in a nutshell, is the number one mistake that people make with trust-based estate plans. And I've seen it not necessarily where it has been a problem, but I have had clients come in to renew their estate plans, to update their estate plans. And, they've had trusts put together in the 80s, the 90s, early 2000s, whenever. And not a single asset had ever been transferred into the trust. So they were under a mistaken belief that when they put that trust together, whomever they did that with, obviously some things fell through the cracks. They believed that they were protected. And in all reality, none of their assets had ever been transferred into the trust. So the work that we do for them is not only updating their estate plan, perhaps doing a restatement of their trust and a new will and all of the other documents that go along with it, but also then helping them to fund that trust, to transfer those assets. And we do that by, obviously, as I talked about before, we do the deeds for the Oregon and Arizona properties, or find an attorney in other states if you have real property in those other states. We do the assignment of your personal property, and then we sit down and have a meeting specifically devoted to educating our clients on how to properly transfer their assets into their trusts. So if you have any questions about this, or you want to make sure that you're putting together your trust in the right way and not making this big mistake, feel free to reach out to me by going to myestateplanmeeting.com. You can schedule a complimentary half-hour estate planning strategy session, either on the phone or in person. I prefer in person. It just makes the process go a little bit smoother, and I can answer any of these any questions you may have about estate planning, and then we can also talk about your options. And if you want to move forward, we can talk about what it will take to get your estate plan in place. Again, my name is Don Rolfe, and until next time, take care. Goodbye.